These certifications है ना?
Good evening, everyone, and welcome to final day of our workshop on alternative dispute resolution. So please join me in giving a warm welcome to our speaker, Advocate Anubhav Jain, sir. Welcome again, sir.
Thank you, Hitesh. Welcome everyone. Good evening, and welcome to the fourth day and final conclusive day of this ADR session. So, today we will be covering topic of negotiation, which is a part of ADR as well, and we will be also dealing into emerging trends in the current ADR system and the growing role of ADR in the commercial and corporate disputes. So, let's begin today's session with the introduction to the word negotiation. So, in simple terms, we can understand that negotiation is a process between two people where both of them try to solve each other's problem, a common problem between them by themselves only. They do not involve any third party to do any process in between. So, it's a process of give and take where they accept, which is like a win win situation for both of them with an acceptable compromise, if I may say. So, so yesterday also someone asked that about talked about the smartphone complaint which he filed towards the company, and the company approached him and asked him whether you want to resolve this issue. We can do it together. So yesterday he was asking whether it is a mediation, whether it is a conciliation or an arbitration. So that process which took place, which the example he gave, it actually comes under the negotiation part of the ADR. So in negotiation, it is not necessary to involve any third party. Both of the parties are enough to get their things resolved with each other. So there are some key features, key elements per se, which are the basis of the negotiation, which you should also keep in mind to the fact that you can do it in a regular life as well. And you being an aspiring advocate, you should also be the part of such processes. So the some of the key elements which you should keep in mind while talking about negotiation, while doing the negotiation, uh, there are basically four steps which you need to keep in mind. First of all, you should know about the anchoring effect. So what is anchoring effect? Anchoring effect is how you start you first offer sets the tone to the this negotiation, like how you start the conversation with the other party. Like for example, if I say we are having trouble with each other regarding some commercial dispute, and in between that we have a spat with each other, the little fight. So while starting in negotiation, if I will take that matter of the little spat which happens between us, it will destroy the negotiation process and will definitely could not help any one of us. So we have to understand that how to start the negotiation. How should you start the this negotiation process? Secondly, you should keep in mind that what can give to the other person, and what you have to stay firm for, which is for the concessions. Like you can stay firm for something like that. I want the possession of a particular property. That can be you can stay firm for it. Like you have bought any property from someone, now he is refusing to give it. Now you want to settle them. You have already paid that person. Now you want to settle it by yourself, among yourself. So what you can do in that process? So the concession part, like you can ask for the money. That's the first thing. But if you want the property, you can ask another party that I want the property. You may tell me the conditions you want to make to me to fulfill. So you have to keep in mind that considering the fact that he is not willing to give you at this moment that property. So you have to give and take. Thirdly, you have to keep in mind the zone of possible agreement. Basically, its short form is ZOPA, ZOPA, the zone of possible agreement. It talks about the environment, the acceptance of the particular thing. Like, for example, you are having a divorce petition pending in the court. Both husband and wife want to settle the matter. Now, husband is earning like 3 to 6 lakh a year. Now, while negotiating for the parties, the girl may seek 1 crore rupees for the alimony. If the person is earning 3 to 6 lakh rupees only, he cannot give 1 crore to the another party. So you have to understand the zone in which the environment in which the party can negotiate. For example, in this case, I was attending one negotiation between the parties of such sort. The girl asked for 1 crore rupees to my client, and my client said, "Sir, I am only earning 3 to 6 lakh rupees a year. I cannot provide 1 crore to the another party." So I simply asked him, "How much can you pay, and how much you are willing to pay?" So he said, "Sir, I can only pay between 10 to 15 lakhs rupees at max." So while discussing this with another person's advocate, I told him that, see, your client is asking for 1 crore rupees, which is not possible for our client. And if you want to continue this case in the litigation process, let's go to the litigation process. We are not ready to settle the matter for 1 crore. Understanding that fact, another party, after going through the ideas of our client, also thought that it is not possible for him to provide 1 crore rupees. So they came down to 15 lakh rupees. So the environment, you have to understand the environment in which both the parties are trying to settle things up. So you have to understand that he cannot pay 1 crore rupees. You may ask for 1 crore rupees, but he cannot pay it in the end. So you have to come to that zone in which he can pay. Then fourthly, there is a element called best alternative to a negotiated agreement. It is a short form for BATNA, BATNA. It talks about while negotiating, you should always know what are your alternatives you have with yourself. For example, in this case, I can tell, if you are going to buy a car, you go to the showroom, you ask the salesperson that I want to buy this car, but he says, no sir, it is available in this variant only. Now, considering the fact that the person who is going to buy that car already has asked some other dealers as well about the same car and the variant available with them, he will tell that car dealer that, okay, if you are unwilling to do so, I might buy it from another party. Considering this fact, the dealer will say, ki, okay sir, if you have done your investigation and you have done your inquiry, I am willing to give you that car on that price and it is available with me. So it is the alternative which you present in the negotiation, that I have other option as well with me, and I can go to that option as well. So while negotiating, you should also keep in mind certain techniques you should follow while negotiating in general as well. For an advocate, it is like the most important thing, like active listening. You should know what other person is saying. You cannot make a deal by ignoring other person's voice. You have to understand what other person is asking. If he is firm about one thing, and it may or may not be in your interest as well, but you have to know what he is seeking and on what ground he is so firm about a particular thing. And secondly, you should know that what encourages a favorable response from the other party. Like I said earlier as well, when you are into some commercial dispute or anything like that sort, you have a little spat, a fight between yourself and amongst yourself. So while negotiating, you cannot put that into table and say, "Yeah, you give me a positive response, you had a fight with me." That will basically destroy the negotiation. You will not get a positive response from the other side. You have to understand that in creating an environment where the other person also thinks that it is in my favor as well and in his favor as well, only then he will negotiate. Otherwise, he will just get away from that negotiation. Thirdly, you should focus on the problem solving approach. What is the problem and how can it be solved? You do not have to create another problem to solve a previous problem. You should have an approach of problem solving. You have to focus on the mutual interest of each other. You have to focus, and you don't have to get into the positions of each other. You have to just focus on the mutual interest, whether, because both the parties in these cases like to win. In most of the cases, like to win. They want to feel that they have won this case, whether they have or not. It doesn't matter. So some example which I can give for the alternative negotiating agreement, like I've said in the car dealing thing. One second. So some of the example I also want to give to the zone of possible agreement where you are negotiating a business partnership. So you want to seek a partnership share of like 60%. Now your partner wants to take the 50% share as well. So while negotiating, while discussing, while keeping in mind your mutual interest, you can say, my zone, my environment in which I'm comfortable is only 60%, is only 50%, and not more than that. So that both the parties get what they want mutually. Now, some of the techniques or tactics I may say to use while doing the negotiation are like tactics. If I talk about, there can be a silent treatment. You see, when you're negotiating, when you feel that another party is giving you a silent treatment, or you are giving another party a silent treatment, he feels that I have said something wrong, or he must have some cards with him. That's why he's playing so tough. You are making other person uncomfortable, which ultimately lead them to the concessions as well. So it is one of the tactics which many good negotiators do while doing the negotiation part. While you may be aware about, usually we see it in Hollywood movies, the good cop, bad cop strategy. You may be aware about it. Most of our Indian families as well, our mom and dad used to do it, where one person while negotiating try to be very rigid about that process. Like, no, you do not get this. Do whatever you want to do, and another person is like, it's okay, I can make some adjustments. So by playing such good cop, bad cop during a negotiation process can also help you to get your favorable outcome. While another technique can be a limited time, like you can give another person, one second. Like a limited time, which they can present that you have a limited time with yourself. You can either choose it, or we are going away with it. Like usually what we make use of while buying an car, if you may say, while in the November, December, they say we are having a limited discount offer for you. So they try to sell more of their cars by saying that. So it is not like they want to give it to you on a discounted price. It is more like they are negotiating with you. They are ready to sell more cars rather than on a higher price. They say that it is a limited time deal, only available in December or in March, because their financial year is closing as well. So they give you little concession, and they try to make, even if you don't want to buy the car, you say, he's giving a very good deal to me, I might think about getting that car. And fourthly, you can use the nibble effect. What is the nibble effect? Asking for a small incremental addition concessions, like in the end of the deal, when the deal is almost over. For example, in one of my cases, when I was dealing with a commercial case against the bank, they said, we have 2 crores rupees loan on you. We have to pay around 4 crore rupees. The balance amount was 4 crore rupees, and the loan which we have taken was of 2 crore rupees. So while having the negotiation, they said the deal was done at around 2 crores 80 lakh rupees. So while doing so, they say, ki, other than 4 crores, you have this penalty. you have another interest on penalty and these type of things. So while closing that deal, we ask them to simply remove those small twerks in the negotiation part, so it get into our advantage, and we saved more 10 to 15 lakhs rupees in that process as well. So it is a large amount. I'm it is not fixed to a large amount. It can be a small amount as well in some cases when we are dealing. In the end of the negotiation, when things are almost done, you can always put in something. Like in the one of my case, I was dealing with the dispossession of on a property. So the tenant and owner of that property was in dispute, and the owner wanted to for the tenant to leave that place. While negotiating, he said he has not paid his rent for last 6 months. He has not paid for the electricity. He has not paid for the water supply and other sorts of things. So in the end, we agreed to pay the rent amount to the owner. But in the end, while the closing the negotiation part, we asked him to let go of the electricity bill to the water bill, which is pending with us. So that is a good technique to do, and it might help a lot of negotiation proceedings as well. So it is not a proceeding; it's just a negotiation between two parties. So what can be your uh, techniques for the success in a negotiation process? So some of them I can share. So you can build a report per se about the things which you already know, and you know that other party knows about you. So you basically, it is a pros and cons you have with yourself, so that you can negotiate in a better manner with them. You can take in into effect to take into your mind that there's a can be a cultural difference between the parties. Some, maybe he can be a big corporate firm, and another can be from a middle class or a rich family or a poor family. You have to take into account all these things in order to get the best deal out of these negotiation, which is a part of the ADR, which is taking place outside the court. The only purpose of these things is to settle the matter outside the court, so you don't have to get into long litigation process. And thirdly, if I must say, you have to prepare thoroughly. You have to research your party's needs and constraint he have. Like if the party cannot pay, you have to know that he cannot pay more than 15 lakh rupees. Then another party, if it is restricted to the possession of a party, you should know that the party in any case will not be able to do a certain thing. He is restricted to certain thing. So you have to know in advance before negotiation, and it is not needed that the advocate have to be present during negotiation. It can be general negotiation as well between two parties too, like yesterday the one of the attendee was asking. So basically, in negotiation, we have two types of negotiation. So firstly, it talks about the collaborative negotiation, and second is a competitive negotiation. So if we talk about collaborative negotiation, it is like a win-win situation for both of the parties. It is a win-win situation for both of the parties. Like both of the parties are winning here. They do not feel like they have lose something. It is a collaborative negotiation. It usually focuses on the mutual gains and building long-term relationships. Like for example, if you are going to buy some steel from the factory, you are a businessman, you need a steel for building your house or to build another person's house. You go and buy a steel from a particular factory. Now that factory, you have made a 70% payment to that person after 3 and 4 months, and your 30% balance is remaining. Now that person refuses to give you second stock of steel by saying you have not paid me 30% of the earlier balance which was left with him. Now while negotiating, you may ask for some time, like you want to buy that particular steel from that factory only because he's giving you the best price. He's giving you the best material you can get in the market. He's giving you certain time limits earlier that you are comfortable with, and that factory person also know that he is a good customer of mine. He usually pay on time. He is doing business with you for a long time. So considering that fact, both of the parties are uh, comfortable doing the negotiation. Like the one person may ask that you may give me 6 months more, 5 months more, I will definitely pay you. And another person is like, keep pay me 10% right now of the balance amount, and I will give you another 5 or 6 months to pay your remaining 20%, and I will release the next stock to you as well. So it's a win-win situation for both of them. Both of them wants uh, to build their long-term relationship. They are already having a long-term relationship with each other. They do not want to spoil their business. They do not want to spoil their relationship of purchaser and seller. And another one is the competitive negotiation. In this negotiation, usually one of the party earns the most of the part of the negotiation and another party wins, but not to that extent. For example, like I have said earlier as well, you are having a loan of rupees, let's say 1 lakh rupees from the bank. Now the bank is charging you an interest, and you have to pay 1,50,000 in total. You have missed your EMI after 3 or 4 months. Now the bank approaches you and say, "Ki, see, you have a balance of certain amount. You have to give the fault charges for not paying. You have to give interest on fault charges. You have to pay this. You have to pay that as a penalty." So in this case, that person will say, "Okay, I will pay. I will pay the whole amount along with interest of 1,50,000. But I do not want to pay the penalty charges. I do not want to pay the other charges which you are charging me for not paying for a single month or a 3 month period." So in this case, you see the bank won the negotiation by saying that, by getting what he wanted, but also at the same time the other person who was ready to pay lost some of the things, like he have to pay the whole amount but not have to pay the extra charges, the extra penalty which which he had to pay if the bank approached the court. So what can be the use of both of these techniques? So in collaborative, when the relationships are important, people used to take collaborative negotiation into consideration, while there's no long-term relationship and parties do not want to have a good relationships in the future. They do not care about the relationship with each other in the future. They usually take competitive negotiation. So our next topic would be emerging trends in ADR. You can see the ADR is still growing. There's not have reached its peak at present moment, because there are other options which is opening in the ADR sector as well. We have also discussed it yesterday, like the online dispute resolution. Like parties do not have to visit to the certain place to attend their matter. They can attend it anywhere, in their own offices, in their own house, sitting anywhere, without spending money on the traveling, without spending anything uh, on the furniture to set for the setup, anything. They can sit anywhere in the world and can attend it. So what all these emerging, that people want, first of all, accessibility. People around India and around the world want accessibility, that they do not want that I have to be limited to visit certain place in order to get my to get the benefit of it, or to get the relief out of it. Secondly, people around the world want things to be cost effective. So while attending online area, you do not you do not need any setup. As I have said, you don't need any furniture. You don't have to pay for the electricity of the certain place. Online, getting it online is very cost effective as well. People don't have to travel. You don't have to arrange staff. You don't have to provide meals. So it is much easier in that respect as well. Thirdly, the ADR process, the online ADR process, is very speedy. You can you can have it on a daily basis, or even at a bilateral basis throughout the day. It can be very speedy. You do not have to wait for certain place to be free. You do not have to you wait for someone to come to the office to attend this matter or anything like that. So fourthly, it is very confidential as well. While you are attending an online session as well, these days there are specific uh, softwares along with us which help us to get the confidentiality part, that the another party cannot join that meeting. And some software are also there which helps to detect if someone is recording or someone is having notes or having anything about it. So the emerging trends in ODR gives you accessibility, gives you cost effectiveness, gives you speed, gives you confidentiality. So if you want a live example of it, I would give the example of Zoom mediation. For example, during pandemic, people were attending courts, people were attending meeting, people were having a issue with each other even after uh, having some pandemic. So want people wanted to communicate with each other, they had mediation with them. In that process, they simply entered a Zoom. They can attend a Zoom meeting in which nobody else can enter, and they can have their problem resolved over there. And secondly, there is a eBay dispute resolution, if you know about it. So when you buy something from eBay and you have some dispute with them, but before taking any legal step or anything of that sort, they have a eBay ODR platform where they come to the online process. You don't have to go anywhere first of all in that thing. You simply can attend that ODR and try to negotiate your things with them. And most of the cases, they try to resolve it as well. So it is a good example. These multi-million companies are also involving in these days. That is, you can take an example of eBay dispute resolution for that. So now, what is the role of ADR in the corporate and commercial disputes? So what do we understand by the essentiality of the ADR in the corporation? So what is the need of it in this corporate and commercial disputes? See, commercial disputes are usually very time consuming and expensive as well, if we go through the litigation process. So ADR offers a faster resolution process to them. If a person is having having a dispute with a big multi-million company, that's a corp, or it could be between two corporations. So instead of going into whole of the litigation process, they usually try to adopt ADR in their process. Like for example, these days even the government is entering into ADR by signing the contracts which they give to the contractors. In the clause, they mention that they have to go to the arbitration in order to resolve in any matter of dispute. So even the government these days are promoting these stuff because they know the court are filled with cases. There are so many cases pending in the court. People will not get justice. The corporate especially will not get their money. They are losing money each day if they are having a large stakes in the courts. So they try to settle the matter in through ADR, which is arbitration in most of the cases of government. So they try to fix things up through that. Second, ADR provides a flexibility. It is more creative, business-oriented solution, which goes beyond the court, which the court may offer. What does that mean? It means that if you go to the court, you ask for a certain thing. You say that this person, I have done his work, he has a contract with me, and now I want my money back. The court can give you money, can provide you with the money only. Now in ADR process, you can negotiate. You can either use the you can use the arbitration as a process to seek other things as well. Like, for example, if I say there's a person who has a contract with the government, now he has completed his work, but the government refuses to pay him due to some lack of work or delay in the work. Now, if he will go to the court can only provide him with the money or the interest. Now, if he rather choose the ADR process like arbitration or negotiation by himself, he can seek other things as well from these platforms. He can ask for another project. He can ask for uh, only interest. He can ask for anything. He is not limited to take the money only. He is giving more opportunity to the government as well to get into the settlement process with them. Thirdly, of course, the corporates do not want their name to be taken by the news channel and say that this corporate has filed a case against this corporate. So they usually prefer the confidentiality between them, and that's why they take things to they take things to the area where they know there's a confidentiality. The people will not know what happened in this ADR process in during this negotiations, during this arbitration. So they are more comfortable as well in that sense because one news can destroy a corporate image sooner or later. So what are the usual common ADR mechanism which we use in the commercial dispute? So basically these days arbitration, mediation and negotiation are the key factors which corporates and commercial people use to get into the to settle their matters between them, because arbitration is a more formalized ADR process when the arbitrator makes the uh, binding decision towards the both the parties. Whereas in the mediation, there's a neutral mediator which helps the parties to communicate and reach an agreement, which is not binding for them to take or not. And thirdly, negotiation, which they can do directly with the other party. They through it can also be done through representation, but basically there's not a third party which is looking upon them and saying, "Kid, now you are right, now you are right, you can," which is also not mediating them. There is no third party. There's not a third party between them. So what is the future of ADR? So globalization of ADR is very relevant these days because ADR has opened a gate for most of the corporates, small businesses, and everyone around the world. Like if you want to expand your business to some other country, let's say, but you think that if I will go to that state or that country, I have to deal with the laws of that country only. ADR process opens the gate for you and say, let's do, let's make business there as well. Let's add into our contract that we will be dealing through arbitration if any dispute arises. So keeping in mind that you don't have to follow their laws, and in case of dispute, the arbitration will be there in which you know that CPC and evidence is also not binding. So it gives you more freedom. It gives you globalization. It gives you freedom to expand your business to the other part of the world. There is also a rise in the international ADR bodies, like you may know about International Chamber of Commerce, which is future enhancing ADR's role in global commerce as well. So ADR in a legal system is also an important aspect which people should know about. Growing emphasis on the ADR by governments, with some jurisdiction requiring ADR process before allowing case to the go to the trial, is also important. Like I have already told you yesterday, like in some commercial matters, there are a necessary pre-litigation mediation, which most of the cases of commercial nature get solved. They do not have to seek the help of the court in order to settle their matter. In mediation, they, before even going to the court, they settle their matter amongst each other. It gives a space to that these parties as well to say, let's say, I'm going to the court. If you want to settle the matter right now, let's settle the matter, or else we will be following the litigation part, which both of the parties know is very rigorous, if especially in the commercial purpose. Secondly, corporate legal departments increasing adopting ADR for cost-effective and faster dispute resolution. Corporate do not want to enter the courts. They want that there should be a confidentiality. Uh, there should be a they don't have to invest most of their time in these courts because it takes a lot of time. So while integrating ADR into a legal system, they already get the arbitration part into their contract so that they know that their matter will be resolved outside the court. Confidentiality will be taken care of, and that would be cost effective as well for them. So it can so ADR, getting ADR into the legal process is very important for them. So there, have you heard about the AI assisted mediation which is taking place right now in America? In this, there is no actual person sitting in the mediations. There is a AI assisted mediations, like you give your input to the computer, and another person also give input to the this system, AI generated system, where they take all the inputs, all the information, all the evidence, everything that mediation AI take, and ultimately, what it does not dictate you that he's right or he or she is right or whatever. He usually gives you the alteration, that what thing you can adopt if you want to resolve these issues. It's a very good thing, but it lacks some human touch in it. So it is still at the growing stage. And secondly, you may heard about the blockchain, blockchain of ADR, blockchain and ADR. So if I give you example of it, these days you are having an auto pay option in the phones. Some apps have even made them compulsory for you to accept the auto pay option, even if you want to carry on for a 1 month only. First, they will always try to make you accept that automatic pay system. You, of course, you can deny it later on as well, but they try to do it. So the basic purpose of it is to, when there's a time for renew of your credit card or renew for the certain app which you want to use, they automatically cut a balance from your account. So keeping in mind that there can be a certain expense in the future, ADR, in through ADR process, you can build and contracts where there is a thing where blockchain is used, where you say that uh, this uh, this much part is done. Now you already have decided through the contract that this much amount would be paid if this much work is done. Both of the parties do not have to get involved in these things. They just have to give the input, evidence, and anything of that sort, which would be feeded into the that computer. The blockchain will automatically get the payment release of that contractor. So I think that that would conclude the today's session, and I would really love to listen to your queries if you have any from these past 4 days. If you have any query, let's open the floor for the questions now. Anyone having a question? You can write it in the chat box actually. What is the full form of BATNA? It is best alternative to a negotiated agreement. It basically means always know your fallback options, your alternative options which you have with yourself. Uh, can negotiated agreements be legally binding and whether there are legal challenges for enforcing the same? During negotiation, there is no not necessarily there can be a contract. It can be it's like a normal contract or agreement which these parties usually do with each other as well. So yes, it is binding. It is like a evidence for you as well if the other party is refusing to adhere to that part of their contract later on if you want to go to the litigation. So, what is the difference between mediation and negotiation? So, as I've said earlier, in mediation, you need the third party who will look upon both of you and will assist you into deciding your terms and condition. He's like a person who is guiding you. Whereas in the negotiation, there's no need of any third person. You and I can negotiate with each other like like you do with a street vendor. If you want to buy an apple, you simply ask him that how much for it you will give it to me. He say 100 rupees for a kilo. Now that type of negotiation is actual negotiation we are talking about here. In e-mandate subscription, if at renewal charges gets dishonored, will NI Act apply? Yes, it will apply. The app can actually sue you for uh, defaulting this mandate e-payment. I've also seen one case where usually you also see this while if you get a loan, your EMI deducts automatically from your account. If you will stop it, then they sue you for it. So it is similar to that sort. How much weightage does architecture degree offers in a real estate dispute for ADR? There's nothing called weightage in this sense, but yes, of course, if their issue is related to the something architectural, then you may contact these arbitration centers and say I have a specialty in this kind of field, and you can approach me if you want any matter which is regarding this architectural thing. In negotiation, what if the other party is aggressive and refuses to compromise? So you follow the litigation as well. Negotiation is like before going to the court, you are asking other person, do you want to settle before going to the court, or I should take the that step only. So it is like that. Here, it is not necessary for the other party to negotiate. It is like a pre-stage which you want to go before going to the court or going for any other method which you want to do. So it's like a stage where you say, "Ki, let's settle it, let's chuck it, let's maintain this uh, relationship or maintain this. We do not have to go to the court." What is the power of arbitrator for execute his arbitral awards? Usually, arbitration awards are executed through courts only. The arbitrator power is to grant that award only. And if you want to appeal, you want to challenge those arbitration awards, you can go to the High Court firstly. There are limited grounds on which you can challenge those arbitration awards, but they are there. You can first approach the High Court, and if the High Court also refuses your petition, you can also go to the Supreme Court under Article 136. You have to take the special leave, of course, first. What is the role of arbitrator in ADR? So it's like arbitrator is like a judge in this sense. In arbitration, people submit their evidence, their contentions, and it is like you're submitting your contentions and evidence to the court. Though the CPC and Evidence Act does not apply on, matlab, it is not limited to the CPC and Evidence Act. So arbitrator has a wide range of power with him, so he or her, in order to decide the matters. I just wanted you to know about the recent case, Sony Z merger case, where the approach SIAC, the current legislature in India, not that effective in dealing with corporate disputes. No, they are effective in dealing those disputes. It's also depend upon these companies whether they want to what steps they want to take in these matters. It is their choice and what is more effective for them. That's the only thing. How autopay mode is related to negotiation. Can understand? Please explain again. I'm not talking about autopay being part of negotiation. I was talking about autopay as a blockchain, which we use in the ADI process, where the people have this blockchain that once the certain work is done, they input it. It is a new thing for us as well. So they are using it in USA for certain things, for dispute resolution, so that people do not have to get into dispute. The work is done, the payment will be done automatically. Is negotiation and conciliation have the same nature of functioning regarding invitation or problem solving sent by one party to another? See, in negotiation, you do not need a third party. In conciliation, you need a third party who will look over both of you, both of the parties, and even more. In negotiation, you don't need a third party. You can obviously send an invitation for negotiation, but it is more like two people conversing with each other and telling their problems to each other and what can be the solution they have with each other. Usually, people try to negotiate first, then they go to the mediation if they want to, or to the litigation. Is it necessary for the parties to not have the third party in the negotiation? Is necessary for the parties to not have the third party in the negotiation. See, these are the terms to explain that what kind of process is called. Like if you have a third party, that would be a conciliation or a mediation. If you are only two parties or a third party having dispute with each other, then it is the process. This process would be called negotiation, and nothing like that. If we add the third party, that would defect the negotiation part. Any other question? What is the future scope of new generation lawyers in a ARB? Arbitration. I'm assuming you have written arbitration. Yes. So, see, arbitration is very booming field these days. But the only thing is, arbitration are usually done by big corporates. So there's a lot of money involved in these things. So as a new generation lawyer, you can always work under someone first and learn about the process. You can learn about anything related to the in the field you are dealing in. Like for example, especially in arbitration, there are various, because these arbitration are happening for one of the reason of these arbitration to happen is there is a specialization involved. Like there is a arbitration for electricity, there can be an arbitration for water supply, anything of that sort. So you have to first decide in which field you want to function, because these big corporates also need the specialized person in that field in order for them to take their case in the arbitration, because it is specialization which they are focusing more and less on the cost effectiveness, because arbitration are obviously expensive. If someone forced the negotiation process, then can these recordings be assumed as evidence? Which recordings? Uh, Negotiation process uh, can be also this confidential. It is not necessary to always have these videotaped or audio taped. So after negotiation, it is up to both of the parties whether they want to sign a contract or they have a mutual understanding in that aspect. Which specialized field is more demanding in arbitration? Every field is very demanding in these days. Especially, I've worked with electricity arbitration. So my experience there was very good. There's a lot of paperwork as well, and because they are doing we are doing it by ourselves, the arbitrators and we us people take very short dates in these things. So it can be like in another 2 days. It can be like another hour. So you it is not necessary that there's any particular field in which uh, there's a current boom. Every field is booming in arbitration these days. It is not necessary that you can say that this field is booming the most. Any other question? You can also unmute yourself if you want. Uh, as I've said, no, there's no need of any third party in the negotiation. As soon as somebody joins for the part for the process, that would become from negotiation to the mediation or to the conciliation. The process is called negotiation. It is not necessary that it should be between only two people. When the third person would come in this into the picture and who is not involved in this dispute, in that sense, that process will be called mediation or conciliation and not negotiation. Any other question? So I hope you learned something from these 4 day session on ADR. And if you have any query regarding ADR or any other thing, you can also send it to my mail. I would definitely love to uh, give you a reply regarding the same. Okay, thank you very much, everyone. As a law student, from which should we start internship to achieve a career in arbitration? By from which I am assuming you are saying from which field or which uh, firm you have to start. You can look into Google and you can also check other platforms which shows that where is the internship program running for these things. There's a lot of opportunity these days, especially in Delhi where I am practicing. There are a lot of opportunities for arbitration as well. Uh, I don't understand. I mean, which year of academics? Which year of academics you mean from when you have to start for the ADR internship? You can do it from the first, second semester as well. You just have to read a little about the ADR and you should know what you are doing. and you can start it from the first, second semester as well. There is no restriction on for any internship per se, but you have to be having a gist to learn. Yes, you can start from the last year as well. It is not necessary to take load that much. You can do it from the last semester as well. Okay, so thank you guys. I hope you learned something. Uh, let's hope to meet again. And thank you very much for having me here.
Michael,
I would like to extend my heartfelt gratitude to you, sir, for generously sharing your profound knowledge and expertise with us throughout. This enlightening session, your presence was truly inspiring, and it was an absolute privilege to attend this session under your guidance. Before ending this session, I would like to call our Chief Human Resource Officer, Mr. Parak Chuk, sir, for vote of thanks.
Thank you, Hitesh, for inviting me. As we come to the conclusion of our enlightening 4-day workshop on alternative dispute resolution, it is my honor and privilege to extend a heartfelt vote of thanks to all those who made this event a grand success. First and foremost, I express our deepest gratitude to our esteemed speaker, Advocate Shum Kumar sir and Advocate Anubhav Jain sir, whose insightful sessions have provided us with a deeper understanding of ADR mechanisms. Your expertise and valuable experience have truly enlightened us and have left us with immense knowledge to carry forward. A special thanks to all the participants who actively engaged, asked thought provoking questions, and contributed to meaningful discussions. Your enthusiasm has been the driving force behind the success of the workshop. We are also grateful to our organizing team, whose dedication and meticulous coordination to the technical support from each member of the Legal Vidya team has played an essential role in making this workshop an impactful one. Also, I want to our host, Karan Chetri and Hitesh Prajapati. Finally, we extend our sincere appreciation to all our supporters who have been a part of this journey. Let's carry forward the knowledge gained and work towards making ADR an effective tool in the legal landscape. Thank you all once again, and we look forward to hosting you in our future events.
Thank you, Legal Vidya, for having us here, me and my partner. Thank you.